Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Before we get started, let's take a brief moment of silence. Thank you. President of the hearing room, we have Commissioners C. Williams, Vice Chair Belzer, Thomas, Powers, and Jay Williams. Joining us virtually, we have Commissioners Irvin and Caston. Before we broke for the day, oh my goodness, did I miss Commissioner Thomas? I'm sorry about that, Commissioner Thomas. Yeah, I thought I said your name, but you know, I'm going off of 2 hours of sleep, so I could have missed you. So thank you. Everyone can stand to be corrected at times. So before we broke for the day last week, the Office of Regulatory Staff was prepared to present this case. Are you ready to go this morning, Attorney Bateman?
Yes, sir, we are. I do have one quick preliminary matter, if I may raise it with the Chairman and Commission. With the Commission's permission, we would respectfully request to give brief closing statements at the conclusion of today's hearing. When I say brief, less than 5 minutes.
Okay, that's fine.
Thank you, Mr. Chairman. With that, I'll turn it over to Mr. Muschin, and we'll begin presenting our case. Thank you.
All right, thank you.
Thank you, Mr. Chairman, members of the Commission. My name is Ben Muschin. I'm appearing on behalf of ORS today, and I will call to the stand Mr. O'Neill Morgan and Mr. Robert Lawyer. And Mr. Chairman, while they're getting situated, just as a brief housekeeping matter, I will be doing the examination of Mr. Morgan, and Mr. Knowles will be doing the examination of Mr. Lawyer.
Sounds good. Thank you.
All right.
Gentlemen, when you're ready, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
If you would turn on your mics and repeat that for me.
Check. Yep.
If you would.
Yes.
Thank you.
Sorry.
All right. You all set? All right. Mr. Morgan, could you please state your name and business address for the record, please?
My name is O'Neill Morgan, and my business address is 1401 Main Street, Columbia, South Carolina.
And Mr. Morgan, where are you employed and in what capacity?
I'm employed by the Office of Regulatory Staff as an senior engineer in the Energy Efficiency and Renewables Department.
Mr. Morgan, I want to take a few minutes and walk through your educational history and background, if I may. Mr. Morgan, for reference, is your CV included as an exhibit to your surrebuttal testimony?
Yes, it is.
Okay. And Mr. Morgan, I see from your CV that you received an associate's degree. Can you tell me what that degree was in and where you received that degree?
Yes, I received my associate's degree from the Caribbean Maritime Institute in Jamaica, and my associate's degree was in industrial systems operation and maintenance.
Okay. And after you received your associate's degree, I see you worked as an energy engineering officer at the Ministry of Energy. Is that correct?
Yes, I worked with the government of Jamaica in the energy ministry.
Okay. And what did you do in that position? What did your job duties entail?
I was employed as a energy engineer officer, and I was involved in implementing energy efficiency and conservation programs under the Ministry of Energy.
Okay. And so that included, did that include energy conservation issues and DSM issues?
Yes, it's around energy conservation issues. I was involved in doing a lot of energy audits at various government agencies conducting these audits, preparing energy efficiency reports and recommendation for all the agency buildings under the ministry.
Mr. Morgan, following that, did you receive a bachelor's degree?
Yes, I received a bachelor's degree from the University of Technology in mechanical engineering.
Okay. And after receiving your bachelor's degree, where did you go to work?
I worked at the power company, utility company in Jamaica, Jamaica Public Service, working in their DSM department, conducting various energy analysis of the customer buildings, doing various audits and calculations as it results to energy efficiency projects that customers were undertaking.
Okay. And did you do any data analysis on energy consumption and demand?
Yes, I was involved in setting up data loggers to collect data to do energy analysis and demand analysis.
Okay. And in 2007, did you return to school?
Yes, I was offered scholarship. I came to the United States to do my master's in engineering management with a focus on industrial systems.
Okay. And what school was that?
That was in Florida International University in Miami, Florida.
Okay. And when did you receive your master's?
I received my master's in 2008.
And after that, where did you go to work?
After that, I went to ICF to work. ICF is a consultant company that manages and implements various energy efficiency, demand side management programs for a lot of utility companies.
Okay. And then I see you later worked as a custom program manager for SC DN, is that right?
Yes, while at ICF, I was involved in a number of development and implementation of utility incentive programs, energy efficiency programs. I was program manager for what is called the custom program. With these utility programs, you have the prescriptive, where you know the energy savings for various measures and the incentives that will be paid. Those are prescribed measures, but for the custom program, each project you have to evaluate on its own, and you have to do a lot of cost effectiveness tests and all of that. So I was a part of the management of many of these programs on the East Coast, starting from Maryland, coming down to Mississippi.
Okay. So as to that last point, let me make sure I understand. Were you a consultant for SC DN, or were you an employee for SC DN?
Consultant.
Okay. And how many, you say you worked for various utilities up and down the East Coast. Could you approximately, how many utilities might that be?
Okay. In Maryland, we have Baltimore Gas and Electric. We had SMECO, Southern Maryland Energy Corp. We had South Carolina, kind of electric and gas now, Dominion. We have Mississippi, and I did some work also. I was on the startup team for Oklahoma Power Company as well. During my time at ICF, I would say I spend a lot of time assisting utility companies implementing these programs, developing these energy efficiency programs. I was involved in hosting a bi-weekly meeting with all my engineers on the East Coast and those in Oklahoma, educating them on how to perform these analysis of various projects, how to implement the program, and involved in answering questions from evaluation, measurement and verification folks, Public Service Commission staff, anything concerning the technical nature of implementing and running these energy efficiency programs.
Mr. Morgan, since you've been at the Office of Regulatory Staff, what kind of work have you done on DSM and energy efficiency programs?
Well, I am involved in the annual review and evaluation of the company's annual DSM-EE program filings. I am involved in various utility filings concerning energy efficiency, DSM programs, DER programs, integration of renewables and leasing programs, and also in the preparation and development of testimonies presenting to the commission.
Okay. So, Mr. Morgan, just kind of looking at your work history and summarizing it, have you helped and have you worked in areas of designing, developing, and implementing DSM and energy efficiency programs?
That's what I did for over 10 years at ICF.
Okay. Mr. Morgan, do you hold any certifications?
Yes, I've done a couple of certification from private companies. I've done certification in photovoltaic design and installation, designing process safety management programs, implementation of National Energy Information System, and energy management certification.
Okay. Thank you, Mr. Morgan. Mr. Chairman, at this time, we would offer Mr. Morgan as an expert in energy efficiency and demand-side management program development and implementation.
All right, sir. Any questions or objections to Mr. Morgan's qualification as an expert in the stated areas?
Mr. Chairman, Ashley Cooper on behalf of the companies. I would like to just get one clarification, see if we could work something out going forward, because we understand that the question was to certify him as an expert in energy efficiency and DSM, and I don't have a problem with certifying him as an expert in EE or DSM. However, ORS has taken the position that parties, certainly the company's parties, may not testify to Act 62, to legal provisions in Act 62, offer legal conclusions in Act 62. And Mr. Morgan, on page 9, starting at line 2 through line 13, offers legal conclusions about Act 62. So, Mr. Chairman, I offer one of two routes. I think that the South Carolina precedent is clear that this commission has broad discretion in allowing testimony. I think that the concerns for undue influence or improper conclusions are minimized when you have a tribunal of experts as you are, as opposed to a lay jury. So I think we could go one of two ways. We could hear these statements from both parties, which are the same statements. I mean, Mr. Morgan is offering a legal conclusion about provisions in Act 62, just as witness Huber, witness Ford is going to talk about their understandings based on their personal experience, based on their training of what Act 62, how to apply Act 62. So we could allow this before you, and both sides can cross-examine the witnesses, and you can decide the weight to give those statements. Or alternatively, I can question Mr. O'Neill right now to strike this provision if they want to try to strike those provisions from Mr. Huber and Ms. Ford, but we can't have it both ways, Mr. Chairman. So I'm just wondering, can we get some sort of agreement up front? I'm happy to allow this statement to stand. I can still cross-examine him, but I don't think what's fair is to, and the reason why I'm bringing it up right now is to allow Mr. Morgan to issue a statement like ORS's position on is not in compliance with South Carolina code. You don't get to put that in, and then when we respond in rebuttal, say, no, that's legal opinion when the company does it.
Mr. Chairman, so a couple things, Mr. Chairman. Number one, I think the question before the commission and before the chair is what to qualify Mr. Morgan in. I understand that Mr. Cooper does not object to him being qualified as an energy efficiency and DSM expert. So I believe that's the question that's pending. With respect to the motion to strike, I believe several things. One, under the Commission's regulations 103-829, the Commission requires motions to be filed 10 days before the hearing, which is what ORS did when it filed its motion to strike. Duke had that same opportunity, and they declined to do so. Second of all, I believe that when you look at the language, there is a difference between Mr. Morgan when he is discussing ORS's position and is based on what the plain language of the statute means versus Duke's witnesses, where they are conflating and trying to interpret and read together language of the statute along with commission orders that much more clearly goes to legal analysis. To the extent that we're going to argue the motion to strike now, I would say what may be a more efficient thing is if Mr. Cooper wants to address that either when we are presenting the pre-filed direct testimony or wants to address that when Mr. Morgan is actually testifying, that would be a more appropriate time to address that issue as opposed to during a qualification of an expert.
I understand. I think he's just trying to. One second, Commissioner Caston. I think he was just trying to come to an agreement up front, but I understand both positions. You're right. The question is whether or not there's any objection to him being qualified as an expert in all the areas that you mentioned, including EE and DSM. Is there any objection to that, Mr. Cooper?
No, Mr. Chairman.
Okay, so Mr. Morgan, you're qualified as an expert in the areas of EE, DSM, and any other area that you requested. We'll handle the other issues when they arise.
Thank you.
Thank you, Mr. Chairman.
Yes, sir. Now, I'm sorry.
Thank you, Mr. Chairman. Just for clarification, I believe that you only sought to have him certified as an expert in EE and DSM. I don't believe there were other areas, correct?
Correct. I said energy efficiency and demand-side management program development and implementation.
Okay. Thank you,
All right.
Mr. Chairman.
Before you get started, Commissioner Caston, did you have a question, sir?
No, sir. Actually, I was going to request if the attorneys and Mr. Cooper in particular could speak more directly into the microphone. I could hear them, but I was trained to do so. So I would appreciate it if they would speak more directly into the microphones. Thank you. That's all.
No problem, sir. All right, please proceed.
All right. Thank you, Mr. Chairman. Mr. Morgan, in connection with this proceeding, did you prepare or cause to be prepared under your direct supervision 13 pages of direct testimony?
Yes, I did.
And do you have any corrections, additions, or deletions to that testimony?
No, I do not.
And if I were to ask you the questions set forth in that testimony, would your answers be the same today?
Yes, they would.
Mr. Chairman, at this time, I would ask that Mr. Morgan's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Morgan's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Mr. Morgan, attached to your direct testimony, you included 4 exhibits identified as exhibits OOM-1 through OOM-4. Is that correct?
Yes, that's correct.
And do you have any corrections, additions, or deletions to those exhibits?
No, I do not.
Mr. Chairman, I would ask that exhibits OOM-1 through OOM-4 to Mr. Morgan's direct testimony be introduced into the record as the next hearing exhibit.
Exhibits OOM-4 through OOM-1 through OOM-4 will be marked and entered into the record as hearing exhibit number 2. Thank you.
Okay. Mr. Morgan, have you prepared a summary of your direct testimony?
Yes, I did.
Okay. Could you present that to the commission at this time, please?
Yes. Good morning, Mr. Chairman and members of the commission. The purpose of my direct testimony is to set forth the results of ORS's examination of Duke Energy Carolinas and Duke Energy Progress's applications for approval of Smart Saver Solar as EE programs. Also to support the recommendations as detailed in the direct testimony of ORS witness Brian Horry. ORS has several concerns with the proposed programs as EE-DSM programs. Number 1, it is not proper to classify customer generator solar PV systems as EE. The installation of a solar PV customer generator does not fit the United States Energy Information Administration and other definitions of EE. Customer-sited solar PV is a source of energy and in no way reduces the consumption of any end-use household equipment for customer generator. Number 2, Duke's proposed programs create significant additional customer costs. The approval of the proposed programs will result in an increase in the current EE DSM riders for the companies. Number 3, the additional costs imposed on non-solar residential customers are unwarranted. The companies estimates that the proposed programs will add an additional cost of $6,733,203 for DEC and $890,836 for DEP over the next 5 years, including the proposed programs as EE will introduce and shift unwarranted costs to the company's non-solar residential customers and provide the company's shareholders with additional net loss revenues and portfolio performance incentives through the existing EE DSM recovery mechanisms. Number 4, Duke's cost effectiveness test results contains serious flaws. ORS found that the company's cost effectiveness test results to be flawed in several important aspects as detailed by ORS witness Horry. Based on these concerns, ORS recommends the Commission deny the company's request. Customer-cited solar PV systems are not EE measures. There is no evidence that customer or company incentives are necessary to encourage installation of solar PV. Certain costs requested are not permissible for recovery under Act 62, and the company's cost effectiveness test results are flawed in several important aspects. This concludes the summary of my direct testimony.
Thank you, Mr. Morgan. Mr. Morgan, in connection with this proceeding, did you also prepare or cause to be prepared under your direct supervision 11 pages of rebuttal testimony?
Yes, I did.
Okay, do you have any corrections, additions, or deletions to that testimony?
No, I do not.
If I were to ask you the same questions set forth in that testimony, would your answers be the same today?
Yes, it would.
Mr. Chairman, I would ask that Mr. Morgan's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Morgan's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
And Mr. Morgan, attached to your rebuttal testimony, you included 2 exhibits identified as exhibits OOM-1 through OOM-2. Is that correct?
Yes, it is.
And do you have any corrections, additions, or deletions to those exhibits?
No, I do not.
Okay, Mr. Chairman, I would ask that exhibits OOM-1 through OOM-2 to Mr. Morgan's rebuttal testimony be introduced into the record as the next hearing exhibit.
Exhibits OOM-1 through OOM-2 will be marked and entered into the record as hearing exhibit number 3.
Thank you, Mr. Chairman. Mr. Morgan, have you prepared a summary of your rebuttal testimony?
Yes, I did.
Okay, can you provide that to the Commission at this time, please?
Yes. The purpose of my rebuttal testimony is to address the rebuttal testimonies filed by company's witness Lee Ford and Timothy Duff. In my filed rebuttal testimony, I address the following matters. Customer-cited solar PV systems are not EE measures. 2, the evidence does not support the assertion that the program's incentives are necessary to encourage installation of solar PV. Under Act 62, certain costs are non-recoverable. 4, costs associated with implementation of the proposed program and flaws are in the company's cost effectiveness test results. Customer-cited solar PV systems are not EE measures. To support the company's assertion that solar PV system is an EE measure, witnesses Ford and witness Duff refer to a single sentence in Commission Order Number 2021-56, which states all self-consumed generation is equivalent to energy efficiency or demand-side management measures as a decrement to system load. However, this statement does not claim that solar PV customer generators are EEDSM measures, as the Duke witnesses suggest. Rather, the plain language of the order directs that the methodology used to evaluate the benefits and costs of customer generation will be similar to how the companies evaluate EEDSM measures. 2, the evidence does not support the assertion that the program incentives are necessary to encourage installation of solar PV. Witness Duff states that existing adoption rates do not reflect the future adoption rates with the solar choice metering programs or the company's proposed programs. However, the companies have not provided any supporting evidence to show that without the proposed programs, there will be a substantial reduction in customers deciding to install solar PV. In fact, since June 1st, 2021, the companies have received a substantial number of new solar choice metering customer generator interconnection applications. This shows customers are willing to make the investment decision to become customer generators based on other financial incentives and marketplace factors without the need for additional incentives funded by the company's non-solar customers. Witness Duff also states that because the program will result in savings for all customers, the companies are not satisfied with the sufficient and adequate solar choice metering tariffs. This statement demonstrates Duke's desire to require all South Carolina residential customers to fund additional incentives for solar PV customer generators beyond that which is sufficient and adequate as determined in the solar choice docket. The company should not be allowed to dismantle the appropriate balance the Commission achieved to implement Act 62's objectives of eliminating the cost shift to the greatest extent practicable while also providing access to customer generator programs through the approval of the company's proposed solar choice metering tariffs. Number 3, under Act 62, certain costs are non-recoverable. Witness Ford claims that South Carolina Code Section 5840-20I only applies to NEMDER costs, which include lost revenues, and conveniently overlook the fact that Act 62 also encompasses future lost revenues associated with customer generators that apply on or after the date of June 1st, 2021. The date is significant because the only program available to new customer generators starting on June 1st, 2021 is the Solar Choice Metering programs. And in order to participate in the company's proposed programs, a customer generator must participate in the Solar Choice Metering program. 4, costs associated with implementing the proposed programs. Witness Duff comments on my focus on the costs associated with the implementation of the proposed programs, in which he said this fundamentally misrepresents how EEDSM programs operate. I fully understand how EEDSM programs operate, which is evident from my 10 years experience working on various utility EE and DSM programs. ORS also performs an annual review of all costs and benefits claimed by the companies associated with EEDSM programs. In these dockets, ORS and E3 reviewed both the costs and benefits associated with the proposed programs and my direct testimony and that of witness holder reflects our full review of the company's proposed programs. It is important to present the costs associated with the implementation of the company's proposed programs to the Commission. This is essentially so, considering that the Commission is being asked to determine whether the company's residential customers should bear these additional costs, in addition to the current costs subject to recovery for Duke's existing EE-DSM programs, regardless of any possible future benefits that may be achieved from the proposed programs. 5, flaws in the company's cost-effectiveness test results. Regarding witness Duff's statement about cost-effectiveness tests and ORS's unwinding and wanting to relitigate what it settled in the settlement agreement approved in Commission Order numbers 2021-32 and 2021-33, these assertions are contrary to what was actually agreed upon by the parties in the settlement agreements approved in Order numbers 2021-32 and 2021-33. ORS strongly disagrees with the company's assertion that other cost-effective tests, such as the TRC, are unconditionally inappropriate for the Commission to consider. While the UCT may be the primary test, other tests remains relevant. Also, the orders do not and could not bar the Commission from considering other cost-effectiveness tests. In addition, the cost-effectiveness test results presented by the companies are flawed in several important aspects, such as the T and D demand reduction values and the free rider percentage used in the calculation. Therefore, the Commission can and should consider other cost-effectiveness tests in its review of the proposed programs. ORS recommends the Commission to deny the company's request on the following basis. 1, customer-cited solar PV systems are not EE measures. 2, there is no evidence that additional customer company incentives are necessary to encourage installation of solar PV. 3, under Act 62, certain costs are not recoverable, and the company's cost-effectiveness test results are flawed in several important respects. This concludes the summary of my rebuttal testimony.
Thank you, Mr. Morgan. Mr. Chairman, as mentioned before, Mr. Knowles will now conduct the examination of Mr. Lawyer.
Good morning, Mr. Chairman, members of the Commission. Alex Knowles on behalf of ORS. Good morning, Mr. Lawyer.
Good morning.
Mr. Lawyer, would you please state your full name and occupation?
My name is Robert A. Lawyer, and I am the Deputy Director of Energy Efficiency and Renewables in the Utility Rates and Services Division of the Office of Regulatory Staff.
Mr. Lawyer, would you please summarize your relevant experience relating to South Carolina DER, NEM, DSM, and energy efficiency programs, program implementation, and cost recovery?
Sure. I received my Bachelor of Science in Finance from Clemson University, and I've been employed with the Office of Regulatory Staff for almost 15 years now. I began my career at ORS as an auditor, reviewing utility cost recovery and annual fuel proceedings, and have worked or supervised the review of over 40 fuel cases in my career at ORS and testified in approximately 19 of them. Through my work in fuel cases, I've also developed a thorough understanding of the methodology and cost recovery related to DER NEM programs. In 2009, I began working on DSMEE matters, including approximately 38 annual reviews of utility DSME program and their cost recovery mechanisms. Through my work in those dockets, I have developed a thorough understanding of the implementation and cost recovery process for DSME programs regulated in South Carolina. In addition, since the passage of Act 62, I've led the ORS implementation and review in the avoided cost cases for both Duke and Dominion Energy South Carolina, the NEM generic docket, and the recent solar choice dockets, providing testimony on 5 of those occasions.
Thank you, Mr. Lawyer. Mr. Chairman, at this time, ORS would respectfully request that Mr. Lawyer be recognized as an expert in South Carolina DER, NEM, DSM, and energy efficiency programs, program implementation, and cost recovery.
All right, sir. Any questions or objections to Mr. Lawyer's qualification as an expert in the stated areas?
No objection, Mr. Chairman.
All right, Mr. Lawyer, you're qualified as an expert in the stated areas.
Mr. Lawyer, are you the same Robert Lawyer who pre-filed 5 pages of rebuttal testimony in this case on October 15th, 2021?
Yes, I am.
Do you have any changes or corrections to your pre-filed testimony?
I do not.
If I asked you the same questions as those posed in your pre-filed rebuttal testimony today, would your answers be the same?
Yes.
Mr. Chairman, ORS asks that the pre-filed rebuttal testimony of Robert Lawyer be read into the record as if given orally from the stand.
The pre-filed rebuttal testimony of Robert Lawyer will be entered into the record as if given orally from the stand.
And Mr. Lawyer, have you prepared a summary of your rebuttal testimony?
I have.
And could you please provide that to the commission?
Sure. Good morning, Mr. Chairman, members of the commission. Purpose of my rebuttal testimony is to respond to the rebuttal testimony of Duke witnesses Lee Ford and Timothy J. Duff. My rebuttal testimony focuses on the following aspects. Number 1, solar PV and EE may both be considered DERs. However, solar PV is separate and apart from EE. Number 2, ORS witness Morgan's knowledge and experience in the areas of NEM, DER, as well as EE and DSM. Number 3, Duke witness Duff's suggestion that ORS witness Ori is not experienced with EE DSM proceedings. And number 4, ORS's concerns with the company's proposed programs. Regarding solar PV and EE, witness Ford ignores the fact that DER program separately identifies EE programs and renewable energy such as solar PV systems. Although solar PV and EE can both be classified as DERs, I have found no support for classifying or equating solar PV as EE as the companies promote in their proposed programs. Regarding witness Ford's assertion that ORS witness Morgan does not recognize the difference between NEM lost revenue and EE net loss revenue, witness Morgan is an experienced senior engineer with impeccable credentials. You've heard them before you earlier. I have personally worked with and trained Mr. Morgan for approximately 2 years now in the areas of NEM DER as well as EE DSM programs. I have the utmost confidence in his knowledge and abilities to perform in his role at ORS. Contrary to witness Ford's statements, witness Morgan's testimony is accurate, and I further support his testimony. Regarding Mr. Ori, and contrary to Duke witness Duff's unsubstantiated suggestion that ORS witness Ori is not experienced in EE DSM programs, Mr. Ori has over 30 years of experience in the energy industry, possesses significant relevant experience, and is fully aware of the framework and history of the company's EE DSM mechanisms, solar choice metering tariffs, and other state jurisdictional programs. It is also important to know that when ORS selects an expert witness to help with evaluating and participating in any case before this commission, it looks for an expert with industry experience and background relevant to the specific case. ORS does not necessarily use the same expert in every case that presents similar issues. Instead, ORS may choose to select a different expert to obtain objective and impartial viewpoints. And lastly, regarding ORS's concerns with the company's proposed programs, the company's proposed solar PV programs are not EE. Recovery of lost revenues associated with customer generators who apply for customer generator programs on or after June 1, 2021 are prohibited. and no additional incentives are necessary or appropriate to continue the growth of renewable customer generation in South Carolina. This concludes my rebuttal testimony summary.
Thank you, Mr. Laura. Mr. Chairman, Mr. Laura is available for questions from the parties in commission.
All right, so my understanding is that the witnesses are presenting as a panel, so the parties and the commissioners will ask questions of both. Let's start with the self-described solar or clean energy interveners.
Thank you, Mr. Chairman. This is Kate Mixon for Clean Energy Interveners.
And Attorney Mixon, before you get started, could you just remind me who all has joined that coalition?
Yes, Mr. Chairman. So our clients are the Southern Alliance for Clean Energy, the South Carolina Coastal Conservation League, Upstate Forever, the North Carolina Sustainable Energy Association, and Vote Solar.
All right. And what about Solar Energy Industries Association?
They're separately represented.
All right, understood. Okay, please proceed, ma'am.
Thank you. Mr. Morgan and Mr. Lawyer, can you hear me okay?
Yes.
Yes, I can hear you. Yep. Yes, I can hear you.
And I'm not able to see the video for Mr. Morgan or Mr. Lawyer on my screen.
All right, stand by.
Great, thank you so much. Mr. Morgan, I want to start off with some questions to you. You state in your testimony that these proposed programs are not energy efficiency. Is that correct?
Yes, that's correct.
Thank you. And on page 4 of your direct testimony, you cite an EIA definition for energy efficiency. Is that correct?
Yes, I did.
And on that same page, you also cite a North Carolina statute defining energy efficiency. Is that correct?
Yes, that's correct.
I'm going to try to share my screen now. If you give me one moment. Okay. Mr. Morgan, are you able to see my screen okay? Do I need to make it any larger?
I don't think you can see it.
It's embarrassing. I have glasses on and I still having difficulty.
Well, no worries. Do you happen to have a copy of Mr. Horry's direct testimony in front of you?
Yes, I do. I can.
I know that this a lot of the same language is also on page 7 of his direct. But this is South Carolina Code section 583740. Are you familiar with that?
Yes.
With this statute?
Mr. Chairman, if I might interrupt, this is an unusual hearing because we're partially in person, we're partially virtual, so I'm just trying to help. I have an extra copy. If it would be of assistance, I'm happy to hand it to the witness, or if I need to place it on the crest here, and that would help the commission, just as an offer of assistance.
If it's the same,
Mr. Mustian, he wants to give your witness a copy of the law. I can pull it up on my computer. All right.
Yep, and what I've pulled up here is just section 583720 in its entirety.
All right, and you can keep that up there. And I believe Mr. Morgan has a copy of it in front of him. All right, he's ready to go.
Great, thank you. Thank you, Mr. Cooper, Mr. Chairman. So, Mr. Morgan, you agree, do you not, that it states that the commission can adopt procedures to for utilities to provide incentives and cost recovery for suppliers that invest in energy supply and end-use technologies that reduce energy consumption or demand.
Yes, I agree with the statement presented in the document before me.
Thank you. Rooftop solar is an energy supply technology, isn't it?
Yes, it is.
And it also reduces energy demand from the utility's perspective, does it not?
Yes, it has the potential to do that. I say potential because it's weather dependent. It's a weather dependent measure, and there are some research collected where it might show that solar PV customers tend to use more energy than they would normally do without solar PV. But I understand it has the potential.
Okay, thank you. And this statute also says that utilities may earn a reasonable rate of return on their investment in qualified demand-side management programs. Is that correct?
Yes, that's the statement.
So the South Carolina legislature, going down a little bit further in this section, they've defined what demand-side activities mean here, haven't they?
Yes, they have.
And do you see where that definition includes renewable energy technologies?
Yes, I see that.
Mr. Morgan, are you aware of any renewable energy technology that would fit either the EIA or the North Carolina statutory definitions that you cited in your testimony?
Well, you have solar water heaters as an example.
Okay, well, Mr. Morgan, let me put it this way. You would agree that rooftop solar is a renewable energy technology, wouldn't you?
Yes, it is.
And wouldn't you also agree that behind the meter savings from rooftop solar reduce the energy requirements of the utility?
Again, yes, there's a potential to do so.
Okay. And do you see where in the definition of demand side activity it says that includes a program for the reduction or more efficient use of energy requirements of the utility or its customers?
Yes, I think I am getting your point, but demand side activities, it's not the same as EE measure. Demand side management includes a column of various activities. You have under the demand side management, you have DER as one activity. You have energy efficiency as one activity. You have planning and implementation of various demand response measures as another activity. So I agree with the statement from the law in terms of demand side activities. What we're saying is PV solar systems does not fall under the EE measures.
Okay, thank you, Mr. Morgan. So to be clear, one, so you're not an attorney, is that correct?
No.
And you don't have any legal background, is that correct?
No, I don't.
Okay. But your testimony is that this definition of demand side activity is separate from the other mentions of demand side programs within the same statute.
My testimony is that energy efficiency programs are a part of demand side activity. So is DER programs, and solar PV is a source, a DER measure, not an energy efficiency measure.
Okay. Thank you, Mr. Morgan. So is ORS advocating that the commission use a different definition other than the definition of demand side activity specified by the South Carolina legislature?
No, we are not.
Okay. Thank you, Ms. Morgan. I'm going to stop sharing my screen here. Okay, Mr. Morgan, I want to again kind of quickly touch on your testimony about lost revenue recovery. Again, recognizing that you're not an attorney, you are familiar with Act 62. Is that correct?
Yes, I am.
Okay. And so you're aware that the legislature made significant revisions to Title 58 when it enacted the Energy Freedom Act.
Yes.
The legislature did not amend the EE-DSM statute that we just discussed. Isn't that correct?
That is correct to my understanding.
Thank you. Your testimony also goes on at length about the cost of these programs. All demand side and energy efficiency programs have costs. Isn't that correct?
Yes, they do.
So, for example, Duke has programs that provide customers with incentives to install more efficient HVAC units, right?
Yes, that is a part of the energy efficiency measure under the energy efficiency programs.
But the point of cost effectiveness testing is to determine whether the benefits of these programs exceed the cost. Isn't that correct?
That is it. That's correct.
Mr. Morgan, I guess starting with your direct testimony, could you please point out to me where you discuss any of the potential benefits of these programs?
I did not present the benefits. We are all aware that there are benefits to solar PV. The issue is, the first issue is it's not an EE measure, and regardless of the benefits, we have to look at the costs. So I focused on the costs. We can also agree that electric vehicles has benefits, but can we afford it? Can we afford it given the additional financial obligations that we have? So I think it was important to present to the commission the additional cost that this program will be placed on the South Carolina residents.
But again, Mr. Morgan, you did just testify that cost effectiveness testing determines whether the benefits exceed the costs, correct?
Yes, I did.
Okay. And you did not discuss any of those benefits in your testimony. Is that a correct statement?
That is correct.
Okay. And what about in your surrebuttal testimony? Could you point out where you described any benefits of the programs in your surrebuttal testimony?
No, I did not present benefits to the commission.
Okay. Thank you, Mr. Morgan. In your testimony, you state that these programs would cause a a cost shift from solar to non-solar customers. Is that correct?
Yes, that's correct.
So generally, for an EE or DSM program, you would call somebody who isn't participating in that program a non-participant. Is that right?
That is correct.
And that's the case for all EE DSM programs.
Yes.
You would agree that some utility EE programs are only available to homeowners, correct?
Yes, that is correct.
And so a renter cannot really, for instance, take advantage of an HVAC replacement rebate. Is that right?
That is correct.
And so the direct participant benefits for those programs will be limited to homeowners, right?
Yes, that's correct.
And if you only looked at those direct participant benefits, you could argue that there is a cost shift from renters to homeowners when it comes to those energy efficiency programs, right?
Yes.
And so in other words, renters are paying into the rider, the DSME rider, that funds those rebates, but they can't actually receive those rebates. Is that correct?
That is correct.
But ORS has never recommended that the commission reject any given EE program for the reason that it's only limited to participation from homeowners, has it?
No, we have not, but one of our basis of rejecting this program is because the company did not provide evidence to support that these additional incentives are necessary for customers to participate in the solar PV program that is being proposed.
Okay, well, thank you, Mr. Morgan. I want to kind of go back to my initial line of questions here. So to the extent that the ORS had equity concerns, about a program not being available to renters, wouldn't it make sense to try to find a way to make those direct program benefits available to renters?
Yes, I would say there is a possibility, but we are not in that realm of presenting or recommending programs that we will turn around and regulate. So we will encourage the company to look at possible programs that those renters can participate in.
Okay. So, in other words, if your goal is, fairness and ensuring, access or ability to participate in programs, you would want to make sure that, more customers had access to those benefits instead of, recommending that the commission scrap the whole program, right?
Yes, but I think the question there, I think you're missing Or's point or issue. Our issue is not that other folks can participate. Presently, customer solar or customer generators can participate in any of the EE programs available. That's not the issue.
But your testimony does discuss the costs to non-participants, does it not?
Yes, it does.
And you also described, again, you discussed a cost shift from solar to non-solar customers, correct?
Yes, for a program that is not necessary for influencing customers to participate in this program.
Okay. Thank you, Mr. Morgan. One moment. With respect to the proposed programs here, you use the phrase, again, non-solar customers a lot in your testimony. The proposed programs here, they would apply to future solar customers, right?
Yes.
So wouldn't you agree that another way to phrase non-solar customers would be potential future solar customers?
Yes, you could
Okay.
categorize
Or another
it as
way.
that. Yes, you could say that.
Or another way, participants versus non-participants.
Yes.
And this incentive would reduce the upfront cost for customers to install solar, right?
Yes, it would.
Couldn't that make rooftop solar more accessible to customers who may otherwise not be able to afford it?
The potential exists.
Okay. And ORS hasn't offered any recommendations for how this program could be adjusted to ensure that it's accessible to all of Duke's customers, has it?
No, we did not. Again, we are, very weary of making certain recommendations without a proper, or I would say, without an official application. Again, we don't want just to eliminate any form of bias or perceived bias. We do not recommend or help to design programs that we in turn have to regulate.
So, Mr. Morgan, is it your testimony that ORS does not believe that it is able to recommend adjustments to or improvements on programs that are proposed to this commission?
Yes, we do make recommendations, but again, through the official filing and through these proceedings, we will make recommendations. But as to the implementation or design of programs, we are not involved in that.
Okay, but here, again, to the extent that ORS had concerns about the program, ORS did not recommend any changes. Instead, ORS is recommending that the commission reject this program in its entirety, right?
Yes, we did not recommend any changes, and if I may point out as well, at the inception of the company proposing these programs, ORS was busy researching and preparing comments as a result of the proposal from the company before we realized that the commission sent out their sent out the proceeding hearings on these cases, that they would like a full hearing on these cases, but we were preparing comments to be filed.
Okay. Thank you, Mr. Morgan. Those are all the questions that I had for you. Mr. Lawyer, I do have some questions for you. Can you hear me okay?
I can. Can you hear me?
I can. Thank you. Mr. Lawyer, ORS signed on to the settlement agreements that were approved by the commission and that made the utility cost test the primary cost effectiveness test for the companies. Is that correct?
Yes, so I do remember that.
Okay.
But that
but
did not exclude the actual looking at the other cost tests as well. But UCT was primary. I agree with that.
Understood. Mr. Horry's testimony is that the commission should reject these programs, at least in part, because they don't pass the total resource cost test. Is that correct?
That is correct.
When one test forms the basis for a commission's determination of a program's cost effectiveness, that is usually considered the primary test, isn't it?
The UCT, is that, did I understand you correctly?
So my question is, so when one test is used ultimately, you know, to be the primary determinant of a program's cost effectiveness, that is called the primary test, right?
Correct. The problem here, Ms. Mixon, is we don't consider this an EE program at all. So
okay.
Other scrutiny outside of that one test is allowable and permissible by ORS to conduct its examination. And I think this commission should have the ability to see all that information to make their determination, not just the UCT test. If this were a flat-out EE program, I would get your point. And that's all we would look at, or make our final determination on with that one test. But no, we need to look at all of them.
Thank you, Mr. Lawyer. And again, you do agree that South Carolina Code 583740 does specifically include renewable energy technologies, right?
583720, you mean?
Correct. Sorry.
Yes, it does, but there's other, I know you asked Mr. Morgan these questions earlier, and if I may go back to that with you. Is that all right with you? You cannot look at this one statute in a vacuum. You need to look at this with 584020 as well. They're intrinsic, they're kind of wed to each other, if you will. You can't look at one without looking at the other. Actually, the 584020 is more current than this one. First of all, as far as, and this does say that those programs need to be cost effective, which we totally disagree with. Therefore, it disqualifies them there. Can they reduce demand? Can they reduce consumption? I would debate that as well. It has the potential, as Mr. Morgan said. Well, in every case, absolutely not. There's a lot more you need to depend on there.
Mr. Lawyer, I appreciate your legal interpretation there. You're also not an attorney, is that correct?
I'll just object real quick if I could. I just want to make sure that Mr. Lawyer had the chance to finish his previous answer.
Sustained.
Apologies, Mr. Lawyer, if I interrupted.
That's okay, Ms. Nixon. What I was going to say, and if I can regather my thoughts for a second, the consumption and demand piece, yes, as Mr. Morgan said, we do believe that has that potential. However, I don't know if the companies have considered what they call rebound effect. I don't know if you've ever even heard of it. There's recent studies out there, one most recently last month from Georgia Tech. Most people that get solar, they actually consume more than they did previously to having solar. So I would say, and then you get onto the cost effectiveness piece again. We don't believe it's cost effective. UCT, TRC, whichever one you feel like using, they don't pass either one. Environmentally acceptable, I'll give you that. I might argue at the end of the life of those panels, what do you do with them? Are they environmentally friendly at that point? I think the jury's still out on that one. And I think those are all the points you covered in there. Yes, you can't look at this one in isolation without looking at Act 62.
Okay, thank you, Mr. Lawyer. Again, I'll ask the question I did a moment ago. You're not an attorney, is that correct?
That is correct. I'm not an attorney.
Okay, thank you. Do you have the language of 583720 in front of you?
I'm sorry, which one? Say that again.
The EEDSM statute to 583720.
What was I just looking at? 583720, what? I have 583720. Is that the one you said?
Yes.
Okay.
You have that in front of you. Okay. Mr. Lawyer, do you see where it says for purposes of this section only, the term demand side activity means, and then it goes on to define that?
I do.
Do you see demand side activity anywhere else in that statute?
I don't believe I do, not at first glance, without reading every word.
You do see demand side management programs, correct?
I thought you said demand side activity.
Yes.
Demand side management programs sufficient to make these programs, yes.
Thank you, Mr. Lawyer. So going back to the settlement, in the EEDSM mechanism dockets for Duke Progress and Duke Carolinas, do you recall when those settlements were proposed to the commission?
I don't know the specific date, Ms. Mixon.
Does December 2020 sound?
That sounds familiar, and I
right
think the order came out in January, maybe.
So that was less than a year ago, correct?
Correct, January 15th.
ORS didn't raise any concerns about the use of UCT as a primary cost effectiveness test at that time, did it?
No, we did not. We agreed with that.
Thank you, Mr. Lawyer. Did you review the surrebuttal testimony of Eddie Moore? Have you reviewed testimony?
I did look at that, yes.
Okay, so if I could direct you to pages 12 through 13 of his testimony, if you have it in front of you.
Page 12, you said, Ms. Mixon?
Right, and specifically I'm looking at lines 3 and 4, and also line 15, 16 to lines 1 through 4 on page 10.
Wait, can we slow down? Let's start with the first lines you said. Surrebuttal, page 12, Eddie Moore. I'm with you there. Lines 3 and 4, you said, I think, first?
Correct. Well, let me ask you generally. Have you reviewed Mr. Moore's testimony on the trend towards using the utility cost test as a primary cost effectiveness test instead of the total resource cost test?
Yes, I vaguely remember the mention. Okay. Without reading it all, I couldn't tell you exactly what it says.
Would you agree? Yes. Would you agree that the total resource cost test is intended to look at the costs and benefits to both the utility and ratepayers as a whole?
Yes, I would agree.
But isn't it true that TRC does not include all non-energy benefits that participants might enjoy from participating in a program, such as health or environmental benefits?
Yes.
And are you aware that there has been a trend away from total resource cost test for this reason? Because it counts all costs, but asymmetrically excludes many of those non-energy benefits.
That may be true, Ms. Mixon. However, I don't understand why you can't even look at that. Why wouldn't you look at the TRC? Why was it included in the company's application if it wasn't important for people to have that information? I think you need to look at them all holistically, in totality, to get a more full picture of what this program is actually going to, or actually has the potential to do. And as Mr. Ori testifies in his testimony, neither of them pass.
Right. Well, thank you, Mr.
So I understand, I'm sorry, go ahead.
I know, I don't mean to interrupt.
I'm finished.
Miss Attorney Mixon and Mr. Lawyer, I know you guys do not mean to interrupt each other, but we are actually paying very close attention to what both of you are saying and would like for you to finish your thoughts. So just sort of pause maybe. Ms. Mixon, once Mr. Lawyer answers your question, give him some time to finish his thoughts. And Mr. Lawyer, allow Ms. Mixon to formulate her question, because we really want to make sure we are getting everything you guys say without you cutting each other off. Is that fair?
That is fair, and I apologize if that's what I did.
No need to apologize. We just want to. At least for me, I'm listening to every word you all are saying. So please take your time.
Thank you, Mr. Chairman. Mr. Horry does recommend in his testimony that TRC, or to state in his testimony that he believes TRC is a more appropriate test to consider in evaluating these programs. Does he not?
I believe he does, Ms. Mixon, and at this point, I'm gonna refer all your questions regarding those tests to Mr. Brian Ori. They're in his testimony. He can testify to them.
Thank you, Mr. Lawyer. These were all my questions about TRC. You do note in your testimony on page 3 that the American Council for an Energy Efficient Economy states that energy efficiency and solar should work together. And you use that to say that it's clear that those are different. Is that correct?
Yes, that is correct. They are different.
Okay. Do you disagree with ACEEE that solar and EE should be used together to create innovative solutions that benefit all ratepayers?
Absolutely not. I do agree with that. As a matter of fact, I think everybody should employ all the energy efficiency they can before they even think about getting solar. That would complement it, but it still doesn't make it energy efficiency.
Thank you. Thank you, Mr. Lawyer. I'd like to bring up Stace and all Lawyer Cross Exhibit 2 this time, and would ask that it be distributed to the commission. I just send this to all of the parties, included witnesses as well, and also share it on my screen. Mr. Lawyer, so this exhibit is the revised comments in the letter of support filed by ACEEE on October 14th in these dockets. Are you familiar with these comments?
I can't see that.
Attorney Mixon, if you could
I believe it may be the same.
zoom in on the document, enlarge it so he can see it, so we can see it in the hearing room.
Mr. Lawyer, do you see that this is a letter from ACEEE titled Letter of Support for Duke Energy's Smart Saver Solar Energy Efficiency Program, filed in this docket on October 14th, 2021?
Yes, I have it in my hand.
Okay, thank you. So are you aware that ACEEE supports these programs?
I don't know if they support the programs as proposed, or they support energy efficiency and solar working together. That's the gist I've got out of this letter.
Mr. Lawyer, you see the last sentence in the first paragraph, starting with our comments below?
Mm-hmm.
Could you please read that sentence?
In our comments below, we express our support for Duke's proposed Smart Saver Solar program and offer recommendations based on the experiences of utilities interviewed through ACEEE research.
Okay, so you do see where ACEEE has expressed support for these proposed programs, right?
Right, and offer
I'm going
recommendations.
to object, Mr. Chairman. Mr. Lawyer can read the letter, but as to what ACEEE believes, what Mr. Lawyer has read can speak for itself.
Ms. Vixen?
I agree, Mr. Chairman. I think that the letter does speak for itself, and was simply asking Mr. Lawyer to confirm that is what it says. It says its proposed program.
Objection sustained.
Thank you, Mr. Morgan. Actually, sorry, Mr. Chairman, I would move to enter the exhibit marked Sace et al. Lawyer cross exhibit 2 into the record as the next hearing exhibit.
ORS would object, Mr. Chairman. ACEEE is not a party to this proceeding. They have not pre-filed testimony. The letter itself is hearsay, and the mere fact that Mr. Lawyer is familiar with the exhibit, it doesn't matter. Under Rule 703, the mere fact that he's familiar with it is not grounds for admitting it into evidence.
Attorney Mixon?
Chairman, Mr. Lawyer cited to ACEEE in his testimony. I think this is useful impeachment testimony that is admissible. Further, I asked him questions about the document on the stand, so it should be admitted into evidence.
Objection sustained.
Thank you, Mr. Morgan, Mr. Lawyer. Those are all of my questions.
Thank you.
Solar Energy Industries Association.
Thank you, Mr. Chairman. Just one brief question, and I'll direct it to Mr. Lawyer. Mr. Lawyer, you agree that a smart thermostat is an EE mechanism?
Smart thermostat, yes. As a matter of fact, they already have an approved program that we do not have an issue with.
Okay. No further questions.
Applicant?
Thank you, Mr. Chairman. Ashley Cooper on behalf of the Duke companies. Good morning, Mr. Lawyer, Mr. Morgan. My name is Ashley Cooper. Nice to meet both of you. I know Mr. Lawyer, but
Morning.
I do that as much to help the court reporter as anything. So I do have a couple of questions that I'd like to go over with you both. Mr. Morgan, I'll start with you. Mr. Morgan, you are aware of the recent EE DSM mechanism orders and settlement agreements, correct?
Yes, I am.
And this, I think you referenced it, this is orders number 2021-32 and 2021-33, those are the orders that approved the mechanisms in the settlement, correct?
Yes.
Okay. And at page 40 of the exhibit, the mechanisms discuss the collaborative, correct? And I can point to that if you'd like for me to read it to you, or if you'll accept, subject to check, that's in the order.
Yes, I agree, subject to check.
Okay. Mr. Chairman, I ask that you take judicial notice of orders number 2021-32 and 2021-33.
Notice taken.
Okay. And Mr. Moore, it mentions the periodic collaborative stakeholder meetings for the purposes of collaborating or discussing new ideas. Is that correct?
Yes, that's correct.
So it's not just a forum for Duke to present its ideas, it's a forum to discuss, test, for all parties to present their feedback, correct?
Yes.
And ORS is a member of this EEDSM collaborative, correct?
Yes, we are.
And do you personally attend these collaborative meetings?
Yes, I have been attending since the past 2 years.
Okay, thank you. And about how often does the collaborative have these meetings?
Every other month.
Okay, so pretty frequently. The program applications, Smart Saver, these program applications were filed in these dockets in April 2021. Subject to check, do you agree with that?
Yes, subject to check.
And did the companies discuss these programs in the collaborative before it filed its application?
Yes, they did.
Okay. And in November 2020, the companies discussed the solar ZE proposal with the collaborative, correct?
Yes, they presented the program.
And the companies circulate minutes from collaborative meetings to the attendees, is that correct?
Yes.
And I'm going to show you, we have, I think we provided Morgan Cross Exhibits 2 and 3 that were meeting minutes. And if I don't know if those are provided, I think we provided that as cross exhibits. And I think, and Mr. Chairman, my colleague, Mr. Middleton, just emailed those out to those who are not here. But I believe we've provided them in advance, so you should have that.
Attorney Mustard, do you have a copy?
Mr. Chairman, could I have just a brief minute to talk to Mr. Cooper about
Yes, sir.
the question? But this is the same. You didn't make any other changes. Yeah, no, I get it. Thank you, Mr. Chairman.
Mr. Chairman, this is Kate Mixon. I just wanted to note that I don't think we have yet received an email copy of the class exhibits.
Okay. So it looks like we received the email.
Morgan Cross too.
Okay. And
Mr. Chairman, I did just receive that email.
my general counsel is telling me she sent them to all parties. Do you have them? Or
Yes,
it?
I just got them a moment ago. Thank you.
All right. let's take about 2 minutes to open those up and review. All right, is everyone ready?
Thank you, Mr. Chairman.
Oh, I'm sorry. Give us 1 second. All righty, Mr. Cooper, your show.
Thank you, Mr. Chairman. Mr. Chairman, I'd ask that the exhibits that we've just distributed be admitted into the record as the next order of exhibits for Morgan Cross, please.
Morgan Cross exhibits 3.
Mr. Chairman, I apologize. Mr. Chairman, I would object. I don't believe that there's been a foundation or authentication laid for this document yet.
Mr. Chairman, I asked Mr. Morgan if he attended the events. I asked him if there were minutes that were kept as part of the as part of this collaborative. He said there were minutes that were kept. There were, and he's been in attendance, so he can look over this list. And I'm happy to go through and ask him about certain members of this test. If he'd like for me to ask him if Gretchen Poole from ORS also attended and he sees them on the list, I can. But it's just going to take additional time. I think we've established the foundation to admit these minutes that are part of the regular point of this collaborative. He's confirmed the dates of the collaborative. He's confirmed the frequency of the collaborative.
Yeah, I got you. I thought you did, but I mean, do you need more, Attorney Mustard?
Well, Mr. Chairman, just admitting that there were minutes that were prepared does not get to the point of, are these the minutes? Has he reviewed these minutes? I think it bears laying a foundation of, is this a document that Mr. Cooper purports it to be?
Please lay more foundation, Mr.
Okay.
Cooper.
All right, Mr. Morgan, you stated earlier that there was a November 2020 meeting. Is that correct?
Yes.
And you stated that you attended that meeting. Is that correct?
Yes.
And you do you know the name Gretchen Poole?
Yes, I do.
Is that somebody who works with you at ORS?
Yes.
Is that somebody who would have attended this meeting?
Yes.
If I showed you meeting minutes, would you expect to see your name on those meeting minutes?
Yes.
Would you expect to see the name of Gretchen Poole on those meeting minutes?
Yes.
Do you know the name Linda Schaefer from Duke Energy?
Yes.
And is it fair to characterize her as the facilitator of these meetings?
Yes.
Okay. At this time, Mr. Morgan, would you look at what we provided to you that's at the top right says November 2020? Do you see that?
Yes, I see that.
Okay. And at the top left, it states DEC, DEP Carolinas. That would be Duke Energy Carolinas and Duke Energy Progress, correct?
Yes.
EEDSM Collaborative Meeting Minutes, correct?
Yes.
That'd be the same collaborative I've been talking to you about, correct?
Yes, it is.
Okay. And it says November 2020, correct?
Yes, it does.
And do you see on the right-hand column, if you look down maybe 70% of the way, do you see your name listed?
Yes.
Okay. Do you recognize the name Tim Duff? With Duke Energy, do you recognize Mr. Duff?
Yes.
And is that somebody you'd expect to be reflected in the meeting minutes?
Yes.
And do you see about maybe 30% of the way down on the left-hand side, the name Mr. Tim Duff appears? Okay.
Yes.
Thank you, Mr. Morgan. Mr. Morgan, based on your review, knowing that the company keeps minutes, knowing that these minutes identify the same meeting that you said you attended, do you have any reason to believe that these are not accurate attendee list and meeting minutes?
No, I do not.
Mr. Chairman, at this time, I ask that the meeting minutes from November 2020 be admitted into the record.
No objection, Mr. Chairman. For efficiency, if I assume Mr. Cooper will go through the same questions of the January 2021, if there were a summary question of would his answers be the same to that document, then we would not object to that as well.
Morgan Cross Exhibit 2 will be marked and entered into the record as hearing Exhibit 4.
Thank you, Mr. Chairman. I can skip some of my questions by asking some of the attendees, Mr. Morgan, because we now covered that pretty carefully. So in those meetings, solar as EE was discussed, correct?
Yes, it was.
And did you report back internally to ORS about solar as EE program after the November 2020 collaborative meeting?
I believe so.
And did you raise questions internally about the benefits associated internally? Is that something you would have brought back?
Not the benefits, but I mean, again, as I'm reminded, I'm not a lawyer. I raise questions on if this is even possible. Plus, okay. This is not energy efficiency measure.
Well, I understand that's a conclusory statement you're making, but you're certified as a technical expert, and I'm asking you if you brought back a technical matter such as the cost, and I believe your answer is no. Is that correct?
No.
Thank you. And solar as EE was discussed again in the January 29, 2021 collaborative meeting. Isn't that right?
Yes.
Okay. Did you at any time in these collaborative meetings provide any feedback or recommendations regarding this program at these collaborative meetings?
No, I did not. This, again, I don't believe I've been going to these meetings for past 2 years, but I don't believe it's our practice to really try to litigate our position within these meetings.
And I believe you stated earlier that ORS cannot recommend programs they'll regulate later. Is that correct? You can't recommend programs that you'll regulate later.
Well, recommend might be the wrong choice of words, but try to design programs.
Okay, design programs. Mm-hmm. But there's no prohibition on asking questions, say, about the inputs to cost effectiveness test, correct?
There's not, and I must say, generally, other programs were discussed as something that the company is being considered, but we like to wait on an official application, which we did, and then we during our discover phase asked the company questions concerning the cost and various elements of these programs.
And there's no prohibition on you flagging concerns, including legal concerns. Even though you're not a lawyer, there's no prohibition on you flagging such concerns during the collaborative. Is that correct?
No, I don't think so. Again, I'm acting on the premise that certain questions that will lead down the track of legality and whether we can state our position in those type of meetings. That was not done. Not aware that it's uh, a custom for ORS to do that. Mr. Lawyer has been attending these meetings more than I have. He might shed some more light on that.
Mr. Lawyer, are you aware of any prohibition on ORS participating in the collaborative meetings?
No, we do participate in the meetings. We're not
Okay.
prohibited. We're actually invited. So we do attend regularly.
Okay. Thank you, Mr.
But I
Lawyer.
must, if I may, I must say these collaborative meetings are a way to get together with various different groups. You listed a lot of them there, to discuss ideas, ask questions if we have them, if they may arise. They may not. Sometimes we have to take things back to headquarters, if you will, or talk to our legal department, talk to our executive officers, things like that. We're not there to develop or help design programs. We're there to monitor, gather information, see what's coming down the pike, see what might be proposed one day. There's nothing finalized in these collaboratives at all. There's no decisions made. There's no going around the room, hey, what do you think? Hey, what do you think? What do you think? None of that happens. We're presented ideas. We do take them back until something's finally proposed. No, we usually don't weigh in to help design those programs.
Thank you, Mr. Lawyer. I just
That's it.
didn't want to, okay.
Finish.
Every so often I start to lean in and there's more, so thank you. Mr. Morgan, okay, well, I appreciate it. I got a clarification from Mr. Lawyer. And I think, so there's no, I think Mr. Lawyer just said, he's standing right here, there's nothing that limits your participation. So there's nothing preventing you from requesting that the company provide an expert and have an expert participation at a collaborative. Is that fair?
That's fair.
Okay. And you can request evidence or data at these collaboratives, is that correct? Nothing prohibits you from doing that?
That's the case, I believe.
And this was discussed in November, and you brought it back, as Mr. Lawyer said, that you brought it back to ORS, and you had until January, until the next meeting. You could have, you're not, as you just said, you're not prohibited from doing any of these things at either the November meeting or the January meeting, correct?
That is correct.
But you nor anybody else from ORS at the November or the January meeting provided feedback on these programs at either one of these collaborative meetings, correct?
No, we did not.
And you did not ask in those meetings about the benefits of these potential programs, correct?
No, I did not.
Okay. I'd like for you to look at page 6 of your direct testimony, if you would. And I'm not going to, Mr. Morgan, again, to speed this along, I'm not going to make you go through pages 6 through 8, but take your time, and if you'd like to familiarize yourself, I don't want to rush you at all, but is it fair to say in pages 6 through 8, you discuss in detail the costs associated with these programs? Is that a fair characterization of your testimony?
Yes, these costs were presented to us through the discovery process. So we asked, once we received the official application, we asked the company as it regards to the cost for these programs, and they were presented to us.
Okay, and likewise, these details about the savings would have been presented to you as well, correct?
Yes.
Okay. So, but in your testimony, your direct testimony, you don't ever detail the savings, do you?
No, I do not. Again, we're aware of we're all aware of the benefits of solar, but again, we have to highlight the costs associated with this in to ensure that the commission have an idea the additional cost that will be laid on the residents of South Carolina.
And Mr. Morgan, I accept that premise that you have an obligation to make this commission aware of the cost, but don't you have an obligation then to make this commission aware of the savings or the benefits?
Yes, the benefits are highlighted in the company's testimony.
And wouldn't the using and consuming public have an interest in you presenting and discussing both the cost and the benefits of a proposed program?
Yes, that would be something that could be done, but again, the benefits or the proposed benefits are presented by the company.
Okay, and Mr. Morgan, I want to turn now slightly to a question on the UCT test, and this is again from the EEDSM mechanism, that proposed order that we discussed earlier, and it's from page 35. And in the interest of time, I'm happy for you to, I think, do we have an extra copy that Mr. Morgan could see? Let me give you just take a second so you can see this. I think you already will know the question I'm going to ask, but
Thank you.
yeah, this would be page 35. Yeah, this is, well, it's 30, yeah, 2021-32 is what I'm reading from. So I'm looking at page 35 where it talks about the utility cost test.
Page 35.
I'm sorry, I can't seem to find a page 35.
I believe my colleague just handed you page 35. Is that right? Maybe you could go show him. Maybe the second page.
Yes, I have it.
Well, can you, Mr. Chairman, may I ask for clarification on what he's referring to?
Yes, Commissioner. This is order number 2021-32. This is the EEDSM mechanism that was an agreement or settlement.
I've got the order. I'm just trying to figure out what page you're on.
It's page 35 of our cross-examination exhibit. It's page 5 of the order.
Thank you.
But I think we provided the is a cross exhibit that you should have. And I believe you've already taken judicial notice. We can email this as well, whatever would be helpful to the
You've
commission.
provided a cross-examination exhibit. Can you tell me which exhibit that is? I don't think we've been handed that yet.
Why don't we email this around and we can enter it into the exhibit enter it into the record just to be clear. I understand this has been a little bit, we're still adjusting. Thank you. Okay, and I think there's a hard copy we've provided that could be passed out. It's Morgan Cross Exhibit number 1, and it'll say Morgan Cross Exhibit number 1, page 33, Morgan Cross Exhibit 1, page 35. Mr. Chairman,
Yes, sir.
I hope this will be in the interest of time. While everybody, I don't mean to further add confusion, but I was thinking maybe while everybody, these exhibits are handed out and everybody takes their time to read it, I just wanted to go back over to clarify something. We offered the two exhibits on the meeting minutes from November 2020 and January 2020. I believe ORS had no objection to those being admitted into the evidence, and I just wanted to confirm that I had moved both the November 2020 and the January minutes into the record.
No, sir. Just the November 2020.
At this time, Mr. Chairman, I'd ask that the January 2021 minutes be moved into the record as well.
No objection.
Morgan Cross Exhibit number 3 will be marked and entered into the record as hearing exhibit number 5.
Thank you, Mr. Chairman. Thank you.
So I'm looking at Morgan Cross Exhibit 1, and I want to make sure the pages, is this not Morgan Cross? Which document does Mr. Morgan have right now?
That's a great question, Mr. Chairman.
Morgan, I have Morgan Cross Exhibit number 1.
Okay, I thought so. So I'm looking at Morgan Cross Exhibit number 1 here, and unless I'm about to receive something.
And I apologize. Let me explain to you what's.
Okay.
Mr. Chairman, I apologize. Here's the confusion. Morgan Exhibit number 1 is the whole. It's the complete order approving the revised DSM mechanism, and it's also the settlement.
Right.
And it's a voluminous settlement and order. So that is all of, and we probably shouldn't have marked it as cross exhibit number 1, but that's the entirety. What I'm now trying to show Mr. Morgan are selected pages of that. And so it's all been moved into evidence. I just wanted Mr. Morgan to look at page 35. What is my page 35 in the exhibit that I put forward to the commission, and you should see something on in italics that says utility cost test.
Mr. Chairman,
Vice Chair Bell.
I apologize, and I don't mean to belabor this point, but this document that says Morgan Cross Exhibit number 1, it is not the entire.
It's not
the entire order, but I have a concern because the first page says order number 2021-32, and some of the pages say 2021-32, but there's some pages that have order number 2021-33.
And I think that's because of the way that the companies, we have a Duke Energy Carolinas and a Duke Energy Progress. It's the same mechanism, same order that's approved. That's why. But if you were to look at the complete document that you have in front of you, not the 2 pages we pulled out in isolation, if you were to look at the voluminous Morgan Exhibit number 1, do you see that?
Now, when you say voluminous, I mean,
This is only 20-something pages. This is not the entire order. This is selected pages.
Now you may mean that to be voluminous compared to 2 pages, but it's not. So my orders here.
Okay, I think what has happened is let me clarify, and I apologize, and understand this is a collaborative. This is another collaborative effort to put documents into the record here. So the order itself is voluminous. I believe that we had a submittal of cross-examination exhibits that were put in last week where we took, because it was such a lengthy document, we condensed it down to certain selected pages. That's what you see, Mr. Chairman, that it's about 20 pages.
Actually, it's 11 pages.
Okay.
Which is fine. Let me
So
ask you this.
then I looked
What
at
do you want in the record?
all I want to do is I want to just ask him some questions about the utility cost test that was agreed to in this stipulation, and that was not provided last week, but I believe we updated our list of documents last night, and it was included. Those pages from the mechanism.
So do you want to enter the 2-page document, Morgan Cross Exhibit 1, or the 11-page document?
I believe we've already admitted the 11-page document. You took judicial notice of that.
I did, but
And so now but as part of,
Oh, the-
but
the
unfortunately,
entire
I'd like to go ahead and admit the entire order, take judicial notice of the entire order is what I
That's been
should do.
done.
Yes, okay. Then we have the 11 pages.
all right.
And then I'd like to ask you about two pages within the entire order. So if the entire order's been put into evidence, there are 2 pages I'm highlighting to you, and I've handed those pages to you.
Right. Okay. Is there any objection to Morgan Cross Exhibit 1, 11 pages, pulled from order number 2021-32 and 2021-33?
Mr. Chairman, there is no objection. I guess I would ask if we're going to admit the orders into the record, I would ask that the entire orders be entered into the record. I know that the commission has taken judicial notice of it. That's a little different than being entered into the record. We have no objection. I would just ask that the entire document be entered in. And then in addition, if I could just ask for a clarification question, I believe the commission had asked and directed the parties to provide their potential cross exhibits sometime last week. I just wanted to make clear that are these new documents that were provided recently, or was this provided last week in accordance with the commission's instructions?
Attorney Cooper?
Yes. So, Mr. Chairman, here's the difficulty with this is so to answer your question, the entirety of the order was difficult to email around to all parties, since this is a partially in-person hearing and a partially remote hearing. So that's why the multiple sets of documents. So the entire order is meant to go into the record. Last week, we provided the number of pages in advance of the hearing start. And then yesterday, for ease, because we couldn't email around the entire order when we started this line, we highlighted these 2 questions, submitted those as cross-exhibit questions so it would make it easier to email to the parties. Arguable whether it did that or not, but that was the intention in doing so.
It sounds like the answer to this question is maybe?
It's a definite maybe, yes,
okay.
sir.
So
But
do you have any? So what's your concern, Attorney Mustin? You want the entire order? Do you have the entire order?
Yes, and I believe that's been admitted into I think the entire order has been admitted.
Yes,
Well, no, I took judicial notice of it.
Yes.
But he wants it, I think you want it admitted into the record. Is that correct?
Well, either if we're going to admit this section into the record as an exhibit, then my request would be that the entire orders, both, all of 2021-32 and 2021-33 be admitted into the record. With that, I would have no objection.
All right. Do you have both orders?
Yeah. Do I have them both in terms of being able to circulate them or?
Right.
Yes, we can provide that.
All right.
Yes,
So
sure.
orders number 2021-32 and 2021-33 are marked as a composite exhibit and entered into the record as hearing exhibit number 6. All right. So all those are in. So do you want to reference some of those pages now?
Yeah. So I'm going to reference what is page 35.
Your page 35?
My page 35.
Okay. What's the order page?
It looks like it's page 29 of 53 in order number 2021-32.
All right. I see that.
And do you see, Mr. Chairman, all right, we're making progress, so I should stop, but do you see the words utility cost test about 30% of the way down? Perfect, we're on the same page.
It's in italics. Yes, sir.
Okay. Mr. Morgan, do you see those words, utility cost test?
Yes, I do.
Okay. And so, Mr. Morgan, would you please read that first sentence into the record on what the utility cost test says?
Utility cost test, UCT, means a cost effectiveness test that measures the net cost of a DSM or EE program or portfolio as a resource option based on the incremental costs incurred by the utility, open parentheses, including incentive costs paid by the utility to or on behalf of participants, close, and exclude any net costs incurred by the participants.
Thank you, Mr. Morgan. In the next sentence, it says the benefits for the UCT are the avoided supply costs, correct?
Yes, that's what it
And then
says.
it gives an example, and it says the reduction in generation capacity costs, correct?
Yes.
Okay. So the UCT test shows, at the end of the day, it's showing whether savings exceed costs. Is that fair?
Yes.
Okay. And this settlement mechanism adopted as the preliminary, not the sole test, but as the preliminary, the UCT test, correct?
Yes.
And so the companies, to put forward their program, they're showing a test which their data, their analysis shows meets the UCT test, correct?
Yes.
And that means, to meet it, that the savings would exceed the costs.
Yes.
And yet you never discussed the savings in either your direct, you never detailed the savings in your direct, your rebuttal, or the collaborative, correct?
No, I did not.
Okay. And as part of this collaborative process, the collaborative itself, those meetings that you talked about and the frequency of the meetings, you understand that there is a true-up process with EEDSM programs. Is that correct?
Yes.
And so if a program that was adopted, if later we showed that the cost and benefits weren't what we thought they might have been, that process is trued up in that later review process in the collaborative, correct?
Yes.
Okay, and you participate in that process as well. I believe you indicate that in your rebuttal testimony on page 7.
Yes.
But you didn't mention that either, did you?
No, I did not.
Okay, thank you. I want to ask you about Act 62, and specifically, I want to ask you about solar choice. If you look at page 9 of your direct, okay, you state on page 2, it is ORS's position that cost recovery of NLR is not in compliance with SC Code annotated 584020I of Act 62, which states, and then you provide a quote which is from the solar choice statute. Is that correct?
Yes, that is correct.
Okay. Were you involved with the solar choice generic docket?
No, I did not.
Okay. Were you involved with the company's solar choice dockets?
No, I did not.
Were you involved with the prior NEM program under Act 236? You realize there was a settlement with the parties and ORS.
No, I was not.
Okay, so you weren't involved in the generic proceeding, you weren't involved in the solar choice, you were not involved with the prior NEM program, but you provide a statement about legal conclusions about Act 62 and solar choice, correct?
Objection, Mr. Chairman. That misstates, mischaracterizes the testimony.
Well, Mr. Chairman, I'm happy to step through each one of those. I think you just stated that you did not participate in the generic, correct?
Yes.
And you did not participate in the company solar choice programs, correct?
Yes.
And you put a statement in the record that says it is ORS's position that cost recovery of net lost revenue is not in compliance with Act 62. Isn't that a legal conclusion?
Objection, Mr. Chairman. I mean, that actually is calling for a legal conclusion as to whether or not it's a legal conclusion. He can ask him what the statement is. He can ask him, does he agree with that? But to interpret whether or not that statement is in fact a legal conclusion is in the province of the chair and the commission.
Ask the question again.
Mr. Morgan, you have a statement that says it is ORS's position that the cost recovery of net lost revenue is not in compliance with SC Code annotated 581020I of Act 62, and then you quote Act 62. Wouldn't your opinion about compliance with Act 62 constitute a legal opinion?
Mr. Chairman, same objection. It's like asking a witness, isn't what you're telling the commission hearsay? That is a question for the commission and the chair to rule upon, not for the witness who is not a lawyer, is not an attorney. We have not offered him as such, to offer an opinion as to what the basis of his testimony is and whether or not it is admittable or not.
Mr. Chairman, how about if I withdraw my question?
If you want to, I'm willing to work through it, but if you
Well,
want to
I want to ask one or two more questions. I might loop back around to it again.
All right.
Okay, I was going to try to move this along, but I think we can draw it out even further. So, Mr. Morgan, let me read this one more time. You state it's the position that cost recovery of net loss revenue is not in compliance with South Carolina Code 5840-20I. Is that correct?
That is correct.
And you stated you did not participate in the generic docket, correct?
Correct.
You did not participate in the company's solar choice dockets, correct?
Correct.
You are not a trained attorney, correct?
Correct.
You're not a licensed attorney.
Correct.
And in your field of study, you not learn the law working as a technical expert for the commission, for the ORS, correct?
That's correct.
And you're not a member of the legislature.
That's correct.
Okay. So, Mr. Morgan, what is the foundation? What was your basis for making this statement? How can you make this statement?
My statement was a result of reading the statement from the law. Electrical utilities are prohibited from recovering lost revenues associated with customer generators who apply for customer generator programs on or after June 1st, 2021. And by reading that statement, the customer generators who apply for these programs after June 2021, those lost revenues that the company may undergo, they cannot recoup those lost revenues from these customers.
Okay. Thank you, Mr.
That's my
Morgan.
understanding.
And so, Mr. Morgan, you just said something very important. You said you read a legal standard, correct?
Yes.
Thank you. And so then would you say that your statement was about the legal standard you just made, correct?
My statement came from my reading of this statement in the law.
And your statement, to be even more particular, was your conclusion about the legal statement you just read, correct?
If that's the legal term, I'm not a lawyer.
Thank you. Thank you, Mr. Morgan. I appreciate that. So, Mr. Morgan, you should be able to provide your statement about the legal standard you read, but when the company's witnesses respond to you, they shouldn't be allowed to provide their views about the statements that they read.
Objection.
Is that correct?
Objection, Mr. Chairman. Again, calls for legal conclusion. More specifically, Mr. Chairman, he's asking Mr. Morgan to render an opinion about the admissibility of testimony, which is in your province, Mr. Chairman.
Well, I understand what he's asking. I'm just thinking through it, working through it mechanically.
My apologies.
It's okay. You got something you want to say?
Well, I can ask him one more question.
Oh, no, I'm thinking about the objection. You just asked him whether or not, essentially, the argument you made at the beginning of the proceeding regarding if he's going to provide testimony, what you believe is a legal opinion, then your witnesses, your company's witnesses, your clients' witnesses should be able to do the same, right?
Particularly, yes, Mr. Chairman, and regardless, they should be able to, particularly when it's rebuttal to his statements and he's not for the foundation we've laid.
Right, but you just raised that question to the witness, though, right?
Well, I have to put something in the record and at least get these things out there in front of the commission so they can consider all this.
I understand. Objection sustained.
Thank you, Mr. Chair.
Mr. Morgan, do you understand that the company's witnesses Ford and Huber provide rebuttal testimony to your conclusory opinion?
Yes.
Thank you.
Mr. Chairman, I would object to that statement based on the characterization as being conclusory. Other than that part of the question, I don't have an objection, but it's a mischaracterization.
I think it's a fair, it's his characterization. I think it's fair. Objection overruled.
Thank you, Mr. Chairman. And are you familiar with the definition of customer generator?
Yes.
You are. And in the definition of customer generator, it talks about interconnection, correct?
Correct.
And it talks about operation in parallel phase, correct?
Yes, subject to check.
And it talks about synchronization with the electrical utility, subject to check, correct?
Yes, subject to check.
Okay. All of those terms would have to do with exporting energy, wouldn't they?
Yes.
And I want to go back and read your statement. The words out of the Act 62 that you referenced, you said electrical utilities are prohibited from recovering lost revenues associated with customer generators who apply for customer generator programs on or after June 1. That's the sentence that you said they don't comply with. Correct?
Yes.
And you just said to me the definition of customer generator relates to interconnection, relates to parallel operation, synchronization, it relates to exporting energy. Isn't that correct?
Yes, it does. It also relates to customers generating their own power.
Thank you. But there's nothing about the EE Saver program that relates to exporting power, correct?
Not to my knowledge, but by virtue of being a customer generator, if you're not using the energy that is generated at that point in time, it's being sent to the grid.
Well, that's true, but now the EE program does not, that program itself, it does not consider, it does not relate to the exporting of power, the EE Saver program that's the matter of this docket, correct?
No, it does not.
Thank you. And I just want to walk through, I think you were asked by Ms. Mixon about, and I handed you the piece of paper that had the EE statute. Do you still have that in front of you? It's section 583720 for those remote and for the commission. I tell you what, we can, I probably have 10 minutes with Mr. Morgan. Can we break then and then I can talk to Mr. Morgan? Do you see this? The EE statute?
Yes.
You talk in your testimony about the cost shift of the company's program, correct?
Yes.
Could you please point to me in this statute on energy efficiency where the words cost shift appear?
The word cost shift does not appear to my knowledge, but cost shift is taking place. I'm not trying to say it's there, but it's taking place. I can't ignore it.
Well, but I think we just talked about with any EE program, there are going to be costs and benefits to participants and non-participants, correct?
Yes.
And that's the whole point of EE, correct?
I don't know if that's the whole point of EE, but that's a part of implementing EE programs.
And thank you for that clarification, Mr. Morgan. That's a fair point. And Mr. Morgan, I know you're not familiar with the company Solar Choice, or you did not participate in those dockets. One final question on the company Solar Choice. Are you aware that the Solar Choice, the company offered an interim rider and then they offered a permanent Solar Choice program? Are you aware of that?
Yes, I am.
And are you aware that the permanent tariffs, the company Solar Choice permanent tariffs, are not in place yet?
Yes, I am.
Okay, thank you very much. I now just want to ask you a few questions. I appreciate your patience and you're working with me through this. I want to talk to you about shareholder incentives. You talk a lot about shareholder incentives on page 7 and 8 of your direct testimony. I want to give you a chance to, if you need to look at that.
Yes.
Okay, I got it. Okay, so I want to read the definition of PPI from the EEDSM mechanism. And PPI, I mean Portfolio Performance Incentive. You're familiar with the term Portfolio Performance Incentive, correct?
Yes.
Okay, and subject to check, I want to read this definition, see if you agree. It means a utility incentive payment to DEC as a bonus or reward for adopting and implementing new EE or DSM measures and or programs. Does that sound like what a portfolio performance and incentive is?
Yes.
And it further states that PPI excludes net lost revenues, correct? Subject to check?
Subject to check.
Okay. And in this collaborative, there was an agreement reached on what the PPI would be. Is that correct?
Mr. Chairman, object. That calls for facts that are not in evidence, I don't believe.
It's directly in the settlement, in the settlement's part of the record. It's 10.6. Subject to check, would you agree that the PPI established in the settlement that's been approved in the order before the commission was amount of 10.6?
Yes, I agree.
Withdraw the objection.
Objection withdrawn.
So you understand that the companies aren't proposing anything new with the incentives. That's something that's allowed for under this agreed to mechanism that's been approved by the commission.
No, I do not object, but my objection is EE being solar PV being classified as EE.
But your testimony on page 7, lines 11 through 13, you say, and I'll give you a second if you want to turn there. It's your direct. It's page 7. It's lines 11 through 13.
Yes, I'm there.
You say the proposed programs would increase this amount with approximately adding an additional $3,539,771, or 53% of the new proposed total cost going to DEC shareholders in the form of net loss revenue and PPI. That's your statement, correct?
Yes.
And you just stated that you understand that it's allowed, a portfolio performance incentive is allowed, correct?
Yes, it's allowed.
And it specifically states that a PPI excludes net loss revenues, correct?
Yes.
But your statement tries to incorrectly blend these concepts that the mechanism says should be separated. PPI is separate and does not include net loss revenues. So it's only by combining those two concepts that you get a larger number.
my table that I presented separate the net loss revenue and the PPI.
Okay, but your statement that I just read combines those two concepts in offering a different number, correct?
My table one is, my intention was to show all the costs associated with these programs that the company will seek to recover. I have separated the PPI and the net loss revenue portion in table one of my testimony.
Okay.
Mr. Chairman, if I may, if we're at a breaking point, and again, I don't know if you still have a few more, but could we take just a quick 5-minute break?
No. We can take a break, but it'd be a lunch break. We definitely can take a break, but if we break, we're going to come back in about an hour or so. Is there something urgent? Or
I have no objection to that.
is that okay? A lunch break?
Fine with me, whether it's 5 minutes or 60 minutes, I'm good.
All right. All right. So are you finished? Are you at a breaking point?
I'm at a breaking point. Yes, Mr. Chairman.
Okay. All right. It is 12:21. We'll be back from our lunch recess at 1:30.
Thank you, Mr. Chairman.